On the evening of July 2, 1964, President Lyndon Johnson sat at a desk in the East Room of the White House and signed a bill that had taken years of protest, organizing, argument, and political pressure to reach his hand. Cameras recorded the ceremony. Civil rights leaders stood nearby. Members of Congress watched a president turn a long national fight into a federal statute. The pen strokes looked orderly. The country behind them was not. The Civil Rights Act of 1964 did not begin with legal language. It began with the daily machinery of segregation. A black traveler could be refused a hotel room. A family could be directed away from a restaurant. A worker could be blocked from a job, a promotion, or equal treatment because of race, color, religion, sex, or national origin. Public life was full of doors that looked ordinary until the wrong person tried to open them. By the early 1960s, movement pressure had made those doors impossible for the federal government to ignore. Sit-ins challenged lunch counters. Freedom rides exposed violence around interstate travel. Birmingham showed police dogs, fire hoses, mass arrests, and children in the streets to a national television audience. The March on Washington gathered hundreds of thousands near the Lincoln Memorial and demanded jobs, freedom, and a comprehensive civil rights bill. The law that Johnson signed was not a gift from above. It was forced upward by people who made private humiliation and local violence into national evidence. President John F. Kennedy had proposed major civil rights legislation in 1963, after Birmingham made the moral crisis unmistakable. Then Kennedy was assassinated. Lyndon Johnson inherited the bill and the presidency at the same time. Johnson had been a Senate master, a Texan, a segregationist system's former beneficiary, and a politician who understood congressional pressure better than almost anyone in Washington. He chose to spend that knowledge on a bill many people expected to die. The opposition was serious, organized, and procedural. Southern segregationists understood that modern law can be stopped not only by speeches against its purpose, but by controlling committees, delaying votes, and exhausting the clock. In the Senate, opponents mounted a long filibuster. Supporters needed cloture, the rarely achieved vote to cut off debate. That meant civil rights had to become not just a moral cause, but a legislative coalition. Republicans and Democrats, liberals and moderates, movement pressure outside Congress and vote counting inside it. When the Senate finally voted for cloture in June 1964, it broke a barrier as important as any single speech. The bill moved toward final passage. On July 2, the House approved the Senate version. Only hours later, Johnson signed it. That sequence matters because it shows how quickly history can move after years of blockage. For a long time, the bill looked trapped in procedure. Then the machinery of Congress shifted, and the ceremony followed the same day. The act attacked segregation across several fronts. Title II prohibited discrimination in places of public accommodation such as hotels, restaurants, theaters, and similar businesses connected to interstate commerce. That meant the lunch counter, the motel desk, and the theater entrance were no longer just local customs when they excluded people by race. They became matters of federal law. The act did not make prejudice disappear. It changed the legal status of refusal. Title VI addressed federally assisted programs. If a school, hospital, or local agency received federal funds, discrimination could put that money at risk. This was one of the Act's most powerful levers because it tied civil rights enforcement to the modern administrative state. The federal government did not need to be present at every doorway. It could condition its money on compliance and make discrimination costly to institutions that depended on federal support. Title VII changed the workplace. It prohibited employment discrimination because of race, color, religion, sex, or national origin and created the Equal Employment Opportunity Commission. The inclusion of sex discrimination would become one of the law's most consequential provisions. Employers, unions, and workers entered a new legal landscape. Again, the law did not instantly produce equality. But it gave people a federal mechanism to challenge exclusion that had often been treated as normal business practice. The statute also strengthened school desegregation enforcement and empowered the Justice Department in civil rights cases. A decade after Brown v. Board of Education, many school systems still resisted. Court orders could be slow. Local officials could delay. The Civil Rights Act helped turn constitutional principle into administrative and legal pressure. It gave the federal government more tools to act when local systems refused to change. This is why the Civil Rights Act must be understood as both moral and technical history. The moral claim was simple. Public life should not be organized by racial humiliation and legal exclusion. The technical achievement was harder, turning that claim into enforceable titles, jurisdictional hooks, agencies, lawsuits, funding rules, and procedures that could survive court challenge and political resistance. Rights become real only when institutions can be made to obey them. The signing ceremony therefore carried more than symbolism. Johnson used the moment to connect the bill to the promise of American citizenship. Martin Luther King Jr. and other civil rights leaders understood both the victory and the unfinished work. The act did not guarantee voting rights. That fight would produce the Voting Rights Act of 1965 after Selma. It did not end housing discrimination. That would require further struggle in the Fair Housing Act of 1968. But it broke the legal architecture that protected segregation in public accommodations and employment. The human consequences were immediate and uneven. Some businesses complied, some resisted until sued, some communities changed because local people forced enforcement. Federal agencies had to learn how to investigate, pressure, and punish. Courts had to interpret the law's reach. Employers had to confront hiring and promotion practices that had excluded whole groups of Americans. A statute is a beginning, not a miracle. But after July 2, 1964, people who had been turned away could point to federal law and say the country had made a promise in writing. The act also changed American politics. It helped fracture the old party alignments that had held together Northern liberals, Southern segregationists, and shifting Republican coalitions. Johnson reportedly understood that civil rights would carry political costs, but the passage of the law also showed that national majorities could be assembled against a regional system of segregation. The United States did not simply wake up more equal. It fought through a political realignment over whether equality would be enforceable. Opponents of the law warned about federal overreach, property rights, local custom, and social disorder. Those arguments had power because they sounded like constitutional caution to some listeners and because they protected existing privileges for others. The supporters' answer was that local control had been used to deny basic citizenship. If a person could not eat, sleep, work, learn, or receive public services on equal terms, then freedom was not an abstraction. It was a route through daily life that the law either protected or blocked. The Civil Rights Act's endurance comes from that daily scale. It was not only about famous leaders or dramatic marches. It was about a room key, a job application, a school desk, a hospital counter, a paycheck, a union hall, a restaurant table, and a theater seat. It moved the civil rights struggle from extraordinary protest scenes into ordinary transactions. That is why it changed public life. It made discrimination in common places legally contestable. Its history also warns against thinking that law and protest are separate worlds. Without protest, the bill could have remained a proposal. Without legal machinery, protest victories could have been absorbed by delay. The movement created urgency. Lawyers shaped language, legislators counted votes, presidents applied pressure, journalists carried images, local activists paid the highest price. The act was the product of all those forces colliding. More than 60 years later, arguments about civil rights enforcement still return to courts, agencies, states, schools, workplaces, and elections. The details change. The central question remains recognizable. When a right is promised, who has the power to enforce it? July 2, 1964 matters because the federal government answered that question with a statute that reached into public accommodations, federal funding, employment, and schooling. The past made clear is that the Civil Rights Act was not a final chapter. It was a hinge. Before it, segregation could hide behind local custom, private refusal, and procedural obstruction. After it, those defenses faced a national law built by movement pressure and political calculation. The act did not make America equal in one evening. It made inequality harder to defend as lawful. That is why the image of Johnson signing the bill still matters. It freezes a single ceremony, but the story is much larger than the desk. Behind the photograph are jailed students, threatened writers, workers denied jobs, families turned away, organizers knocking on doors, senators counting votes, and a country being forced to decide whether citizenship meant access to daily public life. The law's power was not that it ended the struggle. Its power was that it changed the ground on which the struggle would continue.